my name is Cynthia Gallardo, your leading legacy lawyer, and I am so excited to be here with you today. As a legacypreneur, we will be discussing your estate planning needs. You're going to learn so much information today. Before we get started, I want to clarify what exactly a legacypreneur is. So a legacypreneur is someone who has a legacy, an individual with a legacy, such as you and I, right? We all have legacies out there, our past, our present, and what we want to leave for the future, plus an entrepreneur, an individual such as myself who is running my own business, right? We manage it, we lead it, and we run our business. And an intrapreneur is somebody that is managing or running the business of another individual, an organization, another person's business. So either way, as an intrapreneur and or an entrepreneur, you are a legacypreneur. So let's go ahead and get started. So today we'll be talking for about 30 minutes, and I want to share with you what no one else has told you about estate planning. I think you're definitely going to be very interested with this. So today's discussion we will talk as a personal legal consultation. Now, I do want to say, I put a disclaimer out there. I am an attorney by trade, yet this does not create an attorney-client relationship. It's just general information for you. And we'll discuss number 2 here, the will versus a trust, and which one is right for you. And then I'll be giving you a special gift for listening in to today's discussion. And then if you have any questions, I'm able to assist you as well. So you are in the right place. If you know you need an estate plan, but you aren't sure where to get started, you're curious how long the process will take and what's involved, and you're wondering why you just can't do it on your own. Why can't you just do an estate plan online? Very good questions, and we'll go through each of those. So I share with you here my contact information. I am a lawyer, attorney by trade. I'm also a #1 Amazon best-selling author. I am an international speaker, and I'm also a business strategist and or coach. I love helping entrepreneurs and intrapreneurs to excel in whatever background, whatever format, industry that they're in. So here's my contact information. I also want to share with you that I am a credible person. I'm part of many organizations that tie in to what I do with estate planning and the different types of law that I practice. So what are some common objections? My spouse will take over, so what does it matter? I'm too young to need a will. I don't have enough money to need it. Well, those are basically objections, or what I like to say excuses, because each individual needs to identify or look into their specific circumstances, and normally an individual will be better off, have that peace of mind, knowing that they have something established for their estate plan, regardless of their age, regardless if they're married or not, and regardless of how much money they have. So let's move to the next piece. What's the risk to you and your family if you don't have a plan? Well, I can tell you there's a huge risk when you don't plan. And you know that in any aspect of life, especially as a business owner or someone working within a business, you know the importance of planning, planning, planning. So what are the goals of estate planning? That's when you want to give what you have to whom you want, the way you want, and when you want to do it. You can care for yourself during your lifetime, for your spouse, at a time of incapacity, maybe some health and financial situations. You also care for and protect others, and you also avoid probate court. That's one of the options we'll talk about today. And you can fulfill your charitable intentions. You can pass on your values and ideals to children and grandchildren. I always wish that at this point, I lost my 4 grandparents. I wish I would have sat down with them. Basically, take that lifelong learning they've had, right? Those experiences learned, and write them down so I can continue to share those with next generations as well. That's part of this estate planning process as well. Maximizing your assets, distributing the assets to those that you love and those that you want to give them to. It minimizes your taxes due at death, and also protecting your assets from creditors, divorce, bankruptcy for generations to come. So basically, it's having a plan in place to create the best type of legacy out there. Documents of estate planning include last will and testament, or the revocable living trust, a power of attorney, advanced healthcare directive, final disposition instructions, nominations of guardians for their children, for minor children, optional separate trusts for children, and also for those with a $5 to $6 million estate, there's a irrevocable living trust for those type of estates available. So Do you have an estate plan? That's a question I want to put out there to you. You might think you do, but do you really? And it's just, if you don't have one, then the state writes it for you, basically. So it's either you create one or the state creates one for you. Estate planning is opting out of the state's default plan for your family and your assets. That's when you're in control of that seat. You're driving that car. Doing nothing means you get the default plan. And that's what I mentioned earlier. It would be the state that determines the plan for you through intestate law. So the default plan is basically when your assets are distributed according to the state law, and it could go to people you don't want it to go to. You're not able to dictate at that point where your assets will go. Kids get an inheritance at age 18 and it's outright, and that could be lost in some type of divorce down the line for that child, or if it's spent unwisely as well. Spouses could remarry and cause asset distribution to someone other than their children. And then the judge will decide who raises your children if you don't establish that. And the judge will also decide who is in control of your children's money if you don't establish that beforehand. And if you don't have a plan or you don't have a will, or even if you have a will, you must go through probate court. So what about your minor children if you have minor children? Who will take care of your kids if something happens to you? You can name legal guardians in a last will and testament, so that's definitely a benefit there, pre-planning or proactively planning. And if you pass away without a will, a judge will decide who gets custody of your children. Permanent guardianship proceeding. And as we know, that can be very harsh on a child. So you want to definitely make sure that you avoid having to go through this permanent guardianship proceeding where it can be very rigorous, complex, lengthy, and very expensive. And who really loses in that battle? Well, we know it would be those individuals, those minor children, those children, if the court is the one who has to make that decision. So I want to make sure that you have a plan to protect your children. You can name guardians in a will or a trust. You can list backups and say what happens if your guardians get divorced or one passes away. And also, if there are guardians outside Louisiana or outside the state of the United States, excuse me, you want to make sure you have something in place for that. So that's something that, just think of the word proactive or preventative. Just like with your physical body, you want to take preventative care. It's the same thing when it comes to your minor children and your estate plan. So what about the money? What about that money, right? What is an estate? Well, as you can see here, there's a list, checking accounts, saving accounts, vehicles, motorcycles, boats, brokerage accounts, stocks, bonds, life insurance proceeds, houses, other real estate, retirement, IRA, 401k, jewelry, artwork, intellectual property, which I also handle as well, and business interests, your LLCs and other things that are out there. You want to make sure you protect those things. So what are your options? I always tell people I love double dip ice cream. And here you only have two options, but instead of getting those double, right, you need to choose one of them. So you can either have a last will and testament or a revocable living trust. So in this case, a last will and testament is definitely better than nothing at all, right? You want to have something in place. A last will and testament or a will you can name your guardians for your children. You can name beneficiaries for assets owned by you individually, and you can name an executor to wrap up your affairs. So where does a will, I guess for lack of better terms, fail, or do you have some challenges? It's public when filed, not applicable to incapacitation. You cannot cross state lines with a will. Your inheritance at 18, and as I mentioned, it's automatic. And really, is responsible enough at 18? The majority of people are not, to be able to make those life-changing decisions based on what comes to you at that point. No flexibility for giving instructions either with a will. So where there's a will, there's a probate process. I can guarantee you that. So the downside to probate, it can be expensive, time consuming, and it's public. So a lot of us, I know me personally, I would prefer my information to be kept private to protect my child, my minor child. But with the will or to going through the probate process, it is public information. Also, it can be very expensive 2 to 7% or more of the estate assets can be lost in the probate process. So here we give you Rebecca's probate estate, and she comes out. You can see a breakdown there for you. The total probate, let's say she has a total asset value, oh, excuse me for that, total asset value of 4,750,000. So just a 1%, which most likely is not the case, but we'll just go with 1%. $47,500 is lost in probate. So we definitely want to move forward with protecting that, even that 1%. And then we talk about Sam's, right? So before we go to losing that money, let's talk about Sam's probate estate. So he has a asset value of $1,150,000. So let's say we take that estate amount of 1%. So Sam would lose $11,500 in probate. And if it's a 3%, then Sam would lose $34,500 in probate. So what I'm trying to do is help you see that you can actually save that and utilize a different process in order not to go to probate, right? So it's a way to prevent probate. So we look at each individual circumstances and determine what is best for you and your family. So I always share this one here. Nobody wants to throw away money. We want to find ways to save you money in the long run. So what are some other downsides to probate? It can be complex. Families typically need to hire an attorney and get a judge's approval on everything with a probate. And it can be a long process, often taking several months to a few years. So when is a will-based plan appropriate? When an estate plan is less than 125,000 in Louisiana, you can do what's called a small succession, and you don't have to go through probate. And then also an anticipated litigation, you would definitely want to make sure that you use that will-based plan. So your better option in this case, or based on what we talked about, if you don't want to go through probate, you don't want to utilize the other aspects of a will, you can utilize the option of a revocable living trust. So when I say revocable, it can be changed at any time during your lifetime. So you are in that driver's seat. And a revocable living trust can cover everything a will would cover. It will substitute that will, and it will name beneficiaries for your assets in the trust. The trust is revocable, and you can change or amend it at any time during your lifetime, as I mentioned. And you are the trustee during your life. You have total control. You're in that driver's seat during your lifetime with a revocable living trust, excuse me. So a revocable living trust avoids probate if properly funded. And what do you mean by that? Well, basically, if you think about it this way, everything you own now is outside of your trust. You must move your assets into your trust by retitling them to your trust. And that's what we mean by funding your trust. You place your assets into the trust. So the benefit would be everything in your trust bypasses probate when you pass away or when something happens. You still maintain control over the assets in the trust because you're in that driver's seat. You play all the roles. And what I mean by playing all the roles, you'll be able to, I'll show that to you in a moment with a revocable living trust. There's 3 specific roles that you can play. And a revocable living trust is definitely far more flexible than a basic will. And you can have what's called a trust for your children, specifically for your children as well. The ability to nominate one relative as guardian, but someone else to incrementally disperse the money for proper care of the children, or having a checks and balance in place can be utilized. Financial care for your children will happen based on your instructions in a way that protects those funds from creditors and predators. Money meant for your children's care will not be tied up in court until court authentication of a will. So it's automatic, something that happens very quickly. So you aren't trust only for rich people is what I always get asked. And absolutely not. Anybody with assets can create a trust to protect their legacy. So what is a trust? A trust is an agreement that spells out the rules that you want followed for the assets owned by the trust when you pass away. 4 simple things there. It's basically an agreement, right? You lay out the rules, and that's for when you pass away. You have something very specific in place. So what is a trust? Put another way, a trust is all the things people assume that are done by a will. So I want to give you an example with Mr. Dan here. He has one asset, a $100,000 bank account. He wants to leave it to his son Jimmy when he passes away, but he doesn't want Jimmy to get the money until he's 25 and has graduated college. Dan definitely needs a trust to identify those specific things. Because remember, putting these kind of conditions into a will have no legal effect. Basically, you can't put these kind of conditions on a will. It would be that automatic 18, where Mr. Jimmy, the son, would receive that $100,000 bank account. So there are three roles in every trust, as I mentioned. You have what we call in Louisiana the settler and grantor in many other states. That's the person who contributes the assets. Then you have the trustee, the person who manages the trust assets. And then you have the beneficiary, the person who is entitled to the assets. And I'm here to say, I'm very excited to say, you can play all three roles at the same time. So we have here a good couple here, great friends, Henry and Wanda, and they occupy all three positions, the settler, grantor, the beneficiaries, and the trustees at the same time. So they are in control throughout the entire process, and they're in control while they're still alive, and they can make any changes, amendments, or even revoke that revocable living trust during their lifetime. So a revocable living trust is like a kid's backpack. I always think of my son, think of his backpack, and everything inside that backpack is what's protected when it's in a trust, and it avoids having to go to probate. So that definitely will save your family time and money. I always tell people you either put all the time and effort in now and you create this trust. It's a lot more time and effort and money, but long term, your family and friends will have less to do at the end of the day. But if you work with the will, it is definitely simpler now and less expensive. Your family and friends will have to go to probate to receive those assets. So you just want to think about which is best for you and your family. A trust solves all problems that can come with a will. You won't lose 2 to 7% of your estate in probate court. Assets go to your loved ones in a few weeks, not years, and total privacy during your life and even at death, because this information is not out in public court. So I always like to share the positives regarding that. A living trust and guardians. Also, I want you to keep in mind with this, with the living revocable trust, your family will get access to your money much sooner than with a will. Designated guardians will take custody of the minor children, and you may want the nominated guardian to have access to the money as soon as possible, for resources for your minor children. So things parents worry could happen after they're gone. Their adult children get divorced and family assets go to strangers. That's definitely a concern for them. Or their adult children lose their inheritance to creditors or lawsuits. And I'll give you just a few examples. So here we have, oh, I like this quote here actually. Is each child ready for a huge lump sum distribution at age 18? Well, I'll tell you, a financial planning magazine states this specifically. Clients' biggest concern for the wealth after they're gone is that someone will take financial advantage of their children or grandchildren. And it does happen. Here we have the example of Denise and Sam. David and Sarah have the two children. So we talked about David and Sarah previously in the presentation. They have Denise and Sam, and you can see pictures of them here. Well, now we meet Richard, Denise's husband. Well, I don't want to say too much about him, but you can see here that inherited funds are often commingled with jointly held funds. So those inherited funds would be in Louisiana would go from separate property to community property based on that commingling. So if they divorce Denise and Richard, then Richard gets half of everything that Denise inherited. So definitely want to keep that in mind and protect your child, Denise, from that happening. Then we have Sam, who unfortunately very accident prone. He accidentally left the water running in his bathtub and went out for the night. His downstairs neighbors sued and Sam lost his entire inheritance, settling the claim. So here we can see the worst nightmare for parents, It's happening with these two children here. So you want to make sure you protect your children. So a distinct trust for your children can operate like a tube of toothpaste. You take it out slowly, right? Basically, a trust for children can hold their inheritance, and basically you squeeze it out when your kids need it. And that's based on what the trustee would be able to assist them to do until they become of age of majority, right? 18 or over, or the age that you specifically designate. But what remains in the tube is protected from divorce, lawsuits, creditors, and bankruptcy. And you can designate the trustee. And this can even be your adult child at a certain age so that they can take over. So your plan can put protections in place, just like a tube of toothpaste, right? Oh, just a little bit at a time. So that's really important to keep in mind. So how does it all work? A revocable living trust avoids probate. A trust for your children protects your child's inheritance from lawsuits, bankruptcy, and divorce. So what about taxes due at death? Estates greater than these amounts are subject to federal estate tax at death. 12,060,000 for an individual and 24,120,000 for a couple. And then rules are different if you and or your spouse are non-citizens, just to keep that in mind. So how big is your gross estate? Your gross estate includes life insurance proceeds paid at your death. Laws do change, so you could have a taxable estate in the future, even if you don't have it today. You can avoid or minimize taxes due with the help of an estate planning attorney as well. So what are your next steps? Give you just a moment to think about it. You definitely need an action plan. Knowledge is great. Knowledge is power, yet it's not enough. You need to put an action plan in place. What do you need to do? How can you make it happen? When should you get started? And what's the investment to get it done right? So, with that being said, I like to share the process if somebody decides that we can work together, right? First of all, is the attorney's primary focus on estate planning? I can let you know my priority and passion is protecting and preserving legacies, and part of that is estate planning. Does the attorney work with your other advisors? I'm huge about synergy, working together, right? I know me as an estate planning attorney, I can do so many things, yet by working with your insurance advisors, your tax advisors, your financial advisors, we can accomplish so much more for you. And then also, does the attorney charge a flat fee? And do you clearly know what's included with that flat fee? Well, I do charge a flat fee, and I specifically spell out what is included with that. And does your attorney have a process to keep your plan up to date? And yes, I do have a process in place. So I want you to ask yourself, can I see myself working closely with this attorney? So keep that in mind. Just 5 simple steps or a few questions that I wanted you to keep at the forefront of your mind as we go through this. So basically, if you do decide to work with me, it's a 6-step plan and to protect your process, right? Or protect your legacy. Very simple process. Attend a class or a webinar, which you're doing now. Then we would establish a peace of mind legacy planning session where we talk specifically about you and gather the information beforehand so we can sit down and go into the strategic design session. So basically, I take your information from that planning session, that peace of mind session. I'd create a document for you. And number 4, we review the document together. I'd send it to you for review, then we review it together. We have a signing ceremony, number 5, and then a complimentary annual plan review as well. Very simple process. I like to lay it out so you see the big picture first, and then you can break down and determine what next steps you would like to take. So who is the peace of mind legacy planning session for? Someone who has watched our online class or recently recorded webinar, which is what you're doing now. And then also for people who do not have an estate plan or who believe that their plan is outdated. So when I say people, I'm talking about legacypreneurs, right? That's you, that's me, that's those around you, right? Any entrepreneur or entrepreneur with a legacy. And then also people who are ready to get started with the process, and residents of Louisiana. So let's talk about cost. And I always ask this question first. What's the cost of failing to plan? I will only recommend planning if the amount that will be saved by you by this planning is more than the fee. So I always look at it to the best, your best benefit. So some of our most popular packages are the Revocable Living Trust and the Pour Over Will, the Children's Trust, Power of Attorney, Advanced Healthcare Directive, and the HIPAA waiver. Those are all included or bundled together. And then the other option is the Living Will, naming of the guardians, final disposition instructions, portfolio binder, and also electronic copies of the documents. So just want to point out to you, these are the things I work in packaging or bundling, so you get more bang for the buck, so to speak. So I do want to let you know that I am giving, if you sign up after reviewing the session within the next 72 hours, so it would be basically, I said Friday here, but it's anytime you're watching this within the next 72 hours, I will give you a credit if you set up a strategy planning session with me. And how do you do that? You go to www.freestrategycallwithcynthia.com to set up a call with me, and I'd be more than happy to discuss your specific needs. So once again, my name is Cynthia Gallardo, your leading legacy lawyer, and I'm so excited that I was able to share with you the difference between a will and a trust for your estate planning needs to protect and preserve your legacy. Thank you so much. I look forward to talking to you later. Have a great day. Take care.